So on behalf of my colleagues in the Africa and events programs here, I really want to welcome all of you to this very special and very timely panel on the International Criminal Court and Africa. And we have two outstanding speakers here with us right now, Mr. Adama Dieng, the Undersecretary General and Special Advisor to the Secretary General for the Prevention of Genocide, and Mr. Richard Dicker, the Director of the International Justice Program for Human Rights Watch. 7 months ago, in this very room, we had a session called the ICC and Kenya, in which there was a very contentious discussion with regard to whether the International Criminal Court should defer the pending indictment and prosecution of a serving head of state, in that case, the current president of Kenya. Yesterday afternoon, in this very room, we had a discussion on South Sudan and what's going on there. And David Deng, who is a member of the Sudanese civil society, made the very strong point that impunity, the absence of accountability, has an enormous amount to do with one of the root causes of the horrific violence and ethnic killing that's going on in South Sudan today. So we have an opportunity this afternoon to hear about these issues, which pertain not really only to Kenya, but pertain to the entire African continent. Of course, they're global issues, but we're talking about Africa with our two speakers today. And while you have all this in front of you, I just very briefly want to read a small portion of their biographies to you so you understand clearly the background and the commitment that my colleagues here for over 20 years have brought to the issue of justice and accountability for war crimes and mass violence in Africa. Mr. Dieng has been in his current position since 2012, but he served previously as the Registrar of the International Criminal Tribunal for Rwanda. And he has spoken and lectured on human rights, democracy, and the rule of law. He was the driving force behind the establishment of the African Court on Human and People's Rights and the African Convention to Fight Corruption. This was all in the context of the establishment of the African Union in 2000 to 2002, member of the Africa Leadership Forum. Senegal was the first country, I believe, to actually ratify the statute of the International Criminal Court, African country to do so. So Adama brings an incredible background to the subject of today's meeting here. And Richard Dicker has researched human rights issues for Human Rights Watch in Namibia, China, Korea, Guatemala. He started working on accountability at international courts in 1994. Of course, that's a date that registers with everybody here because that was in the aftermath of Srebrenica and Rwanda. And he urged a group of states at that time to bring a case before the ICJ charging the government of Iraq with genocide against the Kurds. He, since 2001, has been the director of Human Rights Watch's International Justice Program. So we're going to sort of take stock today because since this meeting 7 months ago here, there has been the meeting of the Assembly of States Parties of the ICC in The Hague in December. There was the summit meeting of the African Union in the preceding October, where they endorsed the Kenyan president's request for the deferral of any prosecutions. The issue remains on the agenda of the African Union. Given what's happening in both South Sudan and in the Central African Republic, to name only two of the most egregious situations right now on the continent, I think this is very timely. So each of our speakers will talk for 12 to 15 minutes. We've got this condensed panel, which is just great. And then we'll have an opportunity for questions and answers. So we'll begin with Adama Dieng, please.
Well, thank you very much. And from the outset, I would like to give credit to the African countries without whose cooperation the court would not function. And as you know, I have been following the process of the establishment of this court, I would say from the early days. During the Vienna Congress, I was carrying the banner for the establishment of International Criminal Court. At the time, Amnesty was campaigning for the establishment of the High Commissioner for Human Rights. And I do remember in the early days when Bill Pace came to gather support from NGOs. I was the first one, the International Commission of Jurists, to give support to the coalition for the NGO coalition for the ICC. And I think since that time, the NGO coalition has achieved a lot. And I think it will be really justice to record that those achievements and call for further support to the coalition, particularly these days. And I should say that I'm really tired. I'm tired with these usual rhetorics of Africa hates the ICC, and by extension, Africa hates justice, accountability. And first and foremost, let me say that Africa today is committed to move from words to action and to fight impunity. And this has not been the case for many decades, including during the colonial rule. And indeed, Africa has sadly been the situ of numerous atrocities and wars, ranging from wars of independence to civil wars over natural resources and political suppression. And for too long, the world simply looked the other way, while generation after generation of Africans had their lives cut much too short by violence and greed. A culture of impunity characterized the continent as dictators and warlords killed their own people without any repercussion or being called to account. The tide began to change following the events of 1994, when extremists turned a civil war into a genocide, unleashing horrendous suffering never witnessed before in Africa. It is, as you know, estimated that over 1 million individuals, mostly Tutsis, were killed within a 3-month period during the Rwanda brutal civil war. The tribunal established on November 8, 1994 by the United Nations Security Council was the judicial response of the failure of the international community to prevent the mass atrocities and the genocide that occurred in Rwanda in 1994. The negotiation and eventual adoption of the Rome Statute establishing the ICC perhaps stand out as one of Africa's major contributions to the development of international law and international criminal law in particular. The Rome Statute not only has the highest number of its signatures and ratification from the African continent, but also the continent continues to serve as the testing ground for the mission and values of the court. 12 years after the coming into force of the Rome Statute, I think it is clear that all its investigations have been in Africa, and all defendants in custody are Africans. This has led, of course, to the accusation that the ICC is biased against Africa. And though such an accusation does not bear scrutiny, one could speak of perception of bias in light of the fact that all the situation currently before the court concern Africa. And as observed by Professor Charles Jallo, who speak during the last session of the Assembly of State Parties, and I quote, "The African Union has been both clear and consistent from the precipitous moment when the United Nations Security Council decided to refer the Sudan situation to the ICC prosecutor in March 2005, and the subsequent decision of the ICC prosecutor to seek an arrest warrant for President Omar al-Bashir of Sudan, that is not as primarily a regional human rights security body opposed to the prosecution of anyone, whether leaders or foot soldiers, but that is concerned with the timing of such investigation and prosecution. It seems that the African Union position has largely been misunderstood. And I have been arguing with Louis Arbour, who also had more or less the same position. And while international or regional institutions like the ICC, ICTR, or the African Court of Justice on Human and People's Rights continue to contribute to the development and respect of international law by virtue of subsidiarity principle, I would say that sub-regional institutions are closer to the people, and their access may be immediate and cheap compared to most international tribunals whose access may be dictated by resources and time consideration. And that is one of the reasons in the early days of the ICC, I recommended that the trials be relocated when it comes, for instance, to African cases, to Arusha as to host those cases. And I remember even discussing with the Tanzanian authorities, and I remember even the president of the court traveling. So, but at the end of the day, I think many of the judges or people, staff, would prefer certainly the facilities at The Hague than the remote place like Arusha, where I spent 12 years. But I can tell you, I prefer much, much better remaining in Arusha than The Hague, definitely. So I would say also that it is really gratifying to note that the ECOWAS Community Court of Justice, which is headquartered in Nigeria, and while building on the legacy of the ICTR, has reaffirmed the state obligation to punish past war crimes and crimes against humanity. And I think the ongoing trial of Hissène Habré, for which my former staff, Reed Brody of Human Rights Watch, played an important role. I think we should give credit to Reed Brody for the ongoing trial of Hissène Habré, the former president of Chad. I think this exemplifies the crucial role the ECOWAS Court played in compelling my country, Senegal, to fulfill its historic obligation to take concrete measures to put Habré on trial. So the court specifically note, and I quote, "The court shares the noble objectives contained in the mandate of the African Union and translating into practice the adherence of this exalted organization to end impunity for violations of gross human rights violation and to protect the rights of the victims," end of quote. So the unflinching commitment of the court to reaffirm the principles of international law is something worth applauding for all those keen to the development of international law in Africa. And similarly, in its groundbreaking decision against slavery and discrimination in Niger, the court reaffirmed not only the primary obligation of states to protect human rights of their citizens, but also compel states to offer compensation for such violation when they occur. And I remember at the time, the government of Niger, while not happy with that decision, decided to accept that decision and paid the compensation to that young girl who was enslaved. So while we would expect domestic judicial institutions to effectively complement the work of international justice institutions. The reality on the ground demonstrates sometimes that local judicial systems are inadequate to sufficiently respond to the demand for justice that they are supposed to satisfy. And we see justice systems that have been denied appropriate training and financial resources, justice systems whose officials have been bribed, harassed, intimidated, and sometimes even killed, justice systems that have been de facto stripped of their very raison d'etre. And it is these varied and complex challenges facing judicial systems in most African countries that African countries felt the need to establish an African institution that can fill this gap at the regional level and advance commitment and ideals reflected in various instruments adopted to advance human rights in Africa. And I think the recent decision of the African Union to establish a commission of inquiry on South Sudan aimed at ending the violence and bring justice to the victims is a bold step which reflects on the willingness of the African Union to confront the challenges facing Africa and with conviction of resolving them. When serious violations are taking place, there should be no room for complacency, and this seems to be understood today. And words should be backed with actual action. And in this regard, you referred to the debate you had on Kenya. The president of Kenya, who is the chairman of the East African Community, recently stated, and I quote, "It is heart-wrenching for us in IGAD, EAC, African Union, and indeed the wider global community to sit and watch atrocities being committed on a daily basis. This must be put to a stop." And he further called upon all parties in South Sudan to bring their military activities and killing of innocent people to an immediate end and bring to account those involved. This is very welcome. Yet, if we are to reaffirm the progressive development of international law principles in Africa, underpinned by the respect of the rule of law, we have to respect the decisions rendered by these justice institutions. International law principles will remain redundant without impact unless these principles and values embodied in international and regional instruments can be translated into concrete results in the life of the African people. And if you take also the merger of the African Court of Justice and the African Court on Human and People's Rights into the African Court of Justice, this was a landmark decision that laid the foundation for African states to effectively support one another in the shared objective of ending human rights abuses and bring justice to victims. And as some authors have noted, the intended expansion of the jurisdiction of the African Court on Human Rights to try international crimes such as genocide, crimes against humanity, war crimes, will allow the court to continue the work of the ICTR, the Sierra Leone Special Court, in fighting impunity in Africa. But this does not mean that one will close the door of the ICC. The ICC will be there and will remain there, although the dream will be that the ICC one day no longer have any case before it, because a day will come where the African domestic jurisdiction will be of a size and of a quality to handle their cases by themselves and do it domestically, national level, but also domestically at the regional level. But until such a time comes, it is our duty to make every effort to work and cooperate closely with the ICC, as has been the case so far. And I think that is why the resolution which was adopted on complementarity during the last ASP meeting on 27 November by consensus reads, the state parties resolve to continue and strengthen effective domestic implementation of the Rome Statute to enhance the capacity of national jurisdiction to prosecute the perpetrators of the most serious crimes of international concern in accordance with internationally recognized fair trial standards pursuant to the principles of complementarity. My dear friends, the ICC is an independent judicial body that is bound to operate in accordance with its founding treaty and its rules of procedure. It cannot be influenced by political means. It cannot be influenced by other considerations. It is also critical that referral not be limited to African situation, but applies also to other continents where serious crimes are being committed. I'm sure, like me, you all have in mind the intractable conflict in Syria, which is heartbreaking. Every day in Syria, killings continue unabated, and the fighting parties have even prevented international efforts to deliver humanitarian assistance to the vulnerable population inside the country. So the international community is failing to protect the people of Syria. Yet the international community is failing to refer the case of Syria to the ICC. I had the privilege, you mentioned, to be the head of the ICTR, a tribunal which was confronted with grave challenges in its early years, as grave as the one ICC is facing. But it overcame them, including with the support of African states, and gained its stature as a result. So the ICC was tested by the hostility of the US government at an early stage of its work. I mean, we should remember that. I remember speaking with some African leaders who were approached by American ambassador on behalf of President Bush to sign, to say, well, you'll never touch on our people. So, but here we say that today, United States is showing support to the ICC. And we hope that the United States will one day join as a state party. That is not a dream. That will come. So the Syria situation represents a major challenge to the ICC, which must must be overcome if accountability for the most serious crimes of international concern is to be established. Africa has played a critical role in setting up important institutions like the ICC that are tasked with fighting impunity and gross violations of human rights wherever they occur. It was a positive move that the African Union requested that a special segment be included during the last ASP ICC to discuss the issue pertaining to the indictment of sitting heads of state and government and its consequences for peace and stability and reconciliation. To my view, this was a constructive way to address challenges, and I have no doubt that through the proper procedures, the issues will be resolved without violating the principles. And while I have laid emphasis on the importance of Africa taking its commitment seriously as a full participant in making and implementing international law, I would like to conclude by reminding all of us here that this obligation should equally extend to nurturing and supporting regional institutions created to further international law in Africa. And it is only through empowering those institutions, submitting to their jurisdiction, respecting and carrying out their decisions, that they can meaningfully contribute to the articulation of their founding ideals. Empowering these institutions like the African Court of Justice and Human Rights and sub-regional courts, not only will it reaffirm the importance and role of international law in Africa, but it will also demonstrate the commitment and belief of Africa to a global order based on justice, equality, and respect of international human rights values. And as I said, until that time comes, Africa will continue to cooperate with the ICC, and we will call for the continuation of that cooperation. And I have no doubt that all these issues will be belonging to the past. And I thank you.
Well, thank you very much, Adama. This is a very powerful statement, and not only a summation of where matters stand, but a kind of a challenge both to Africa and African states and to the what we call the international community. And certainly your points about Syria not being in any way at this point on the agenda of the ICC puts this forward in a very strong way. So our next speaker will be Richard Dicker, and then we'll have our discussion. Richard.
Yeah. Thank you very much, Ambassador Hirsch, and thank you all for coming out this afternoon and participating in this discussion, which indeed is a very important one. I want to begin by referencing a point that both Ambassador Hirsch and Adama Dieng made in recalling the genocide in Rwanda in 1994 and the horrific crimes that occurred in the former Yugoslavia, both before and after the Rwandan genocide. And I do that because I see those terrible events as a real triggering moment, a moment that I think imbued the international community with a determination to go forward in a concerted effort to pierce the impunity all too often associated with horrific crimes and create a permanent international criminal court that would not be limited to just one or another jurisdiction and would not be turned on or off like a light switch by the United Nations Security Council. There is a direct nexus between the horrific events in Rwanda between April and June and the establishment of the International Criminal Court that got underway as a legacy. And I think over the last 10 or 12 years, really it's important to see that expectations on the part of victim communities, on the part of civil society, on the part of governments and intergovernmental organizations for justice and accountability have increased dramatically as a direct result of both the ad hoc tribunals, the Sierra Leone Special Court, and the first decade of the ICC. You see the evidence of that increase in expectation in the signs that protesters in Damascus carried back in the spring of 2011, saying Assad to the Hague. And you see it again in the report of the Commission of Inquiry on the DPRK, recommending the United Nations Security Council refer the situation in North Korea to the International Criminal Court. The fact is that justice has emerged on the landscape as an active means of addressing conflict, and I believe whatever backlash there has been and may be, this will not change. It reflects a tectonic shift in the landscape and a very welcome one for those at risk wherever they are for serious crimes. Now, that said, it's not surprising that there would be backlash to these developments and the ICC in particular. Adama mentioned, and I'm glad you did, the current wave of antipathy emanating from a few African states, of some not state parties, others state parties to the Rome Statute, is hardly the first backlash that the ICC has encountered. And I remember those examples very clearly between 2002 2005, when the George W. Bush administration made every effort to derail the court. I think it's important to keep that practice in mind as a way to contextualize some of the backlash that we've seen coming from a few African states. Now, that is exacerbated. The backlash is exacerbated by an ugly reality, which I think we have to acknowledge, and that is that the Rome Statute of the ICC, unfortunately, does not apply equally to all. Now, that's not a flaw of the ICC, its prosecutors or judges. That is a characteristic that the states who met in Rome in June and July of 1998, at the very last moment, insisted on including in the Rome Treaty to limit the reach or scope of the court. And in practice, unfortunately, what it means is those in the most powerful governments and those the powerful governments protect, whether they are in Sri Lanka, Syria, or Israel, remain beyond the reach of the ICC. And that reality is something that needs to be changed, and we need to commit ourselves to change it. But to deny justice or obstruct justice for victims in Darfur simply because it's not possible to bring victims in Gaza justice makes the perfect the enemy of the good, and I think contains no logic. The unevenness in the reach of the ICC statute and the contention emanating out of Africa has also been exacerbated by, as Adama referred to, the history of centuries of colonial rule marked by some of the most brutal practices imaginable, for which there never was any accountability. I'm glad to see British courts give victims from Kenya who were detained allegedly as Mau Mau back in Kenya's independence struggle some compensation for abuses experienced. But there hasn't been accountability for the horrors that were associated with colonial rule. And I think that unfortunate reality is what gives more resonance than is deserved to the narrative that the International Criminal Court was created to persecute African leaders. I think we all know the facts do not sustain that narrative, but that's the one we hear. We all know that of the 8 situations in Africa, 5 were requesting the ICC prosecutor to come in. 2 were referred by the Security Council, and only 1 was initiated on the effort of the prosecutor himself. I mean, those are the facts, and the narrative of persecution, I believe, is a boogeyman that takes life from the ugly reality of colonial rule in Africa. Now, I want to look forward in terms of ways that this contentious relationship, and let me be clear, the contentious relationship is not between the International Criminal Court and justice more broadly on the one side and all Africa on the other. I was in Mali last week, talking with civil society, government officials. We met with the Minister of Justice. And you may remember, of course, that Mali, as a result of the crisis that happened there in 2012, requested the International Criminal Court to come in. I think that reality of support and engagement with the court on the part of African governments is much, much more extensive than the distorted narrative of ICC v. Africa sustains as well. And certainly, one of the very encouraging and important realities of the last few years has been the emergence of African civil society organizations, differing with those in the leadership of the African Union, who seek to undercut the court. These civil society groups across the continent, in every sub-region, express their commitment to justice. So there's a narrative that's been woven that I believe is worse than mythology and bears no reality to the facts on the ground. But in improving the relationship between the court and the African continent as a whole, I want to flag 3 points. First, leveling the playing field. I'm a little jet lagged from the trip back from Mali, so you have to excuse me. Leveling the playing field. I referenced before that there's an unevenness in the way the court is able to apply its own statute. Well, I think African states and African states parties in particular have opportunities coming up in the near term to demonstrate the commitment contained in the Constitutive Act of the African Union, as well as the Rome Statute of the ICC, to demonstrate a very vigorous commitment to the fight against impunity. First, by broadening, helping to broaden the docket or the caseload of the court. Very specifically, in the next 10 days, at the Security Council, France will introduce, as has been referred to, a resolution referring the situation in Syria to the ICC. Now, interestingly, this resolution is open to non-council members co-sponsoring. And I would think that every member of the international community that is genuinely committed to the fight against impunity would lend its name as co-sponsor to that resolution. And I would urge African states that have criticized the court because all of its cases are concentrated in Africa to lend a hand in bringing justice to victims in Syria, and in a secondary way, helping break out of the African focus that the court has had due to the limitations of its own statute. Number two, in the fall, the Third Committee of the General Assembly will discuss a resolution on DPRK. And let's see states committed to the fight against impunity, including African states, lend a hand to passing that resolution with an overwhelming majority. And lastly, there's a third opportunity, and that is, as unfortunately the peace talks between Israel and Palestine have faltered, if not broken down, the issue of Palestinian ratification of the Rome Statute is emerging into the light. And I think it's the obligation or responsibility of every ICC state party committed to justice to support Palestine's prompt ratification of the Rome Statute. And we would look to African states to lend their weight to help make that ratification happen. So that's one step, leveling the playing field. A second step in improving the relationship would occur at the African Union, and in particular, the African Union summits itself. African states parties committed to the fight against impunity can and should do more to prevent measures not aimed at constructive criticism of court practice, but aimed rather at undercutting the court's work. And I'm thinking of the resolutions adopted in the last few years of non-cooperation in the matter of the arrest warrant against Sudanese President al-Bashir. I think that there is room for African state parties in the environment of Addis and the AU summits to stand up for principle in that important regional organization, which to a certain extent has lent itself to an anti-ICC agenda. Let me get specific. For a number of years, the court has sought permission to open a liaison office to the African Union in Addis. That request by the court, aimed at improving communication, has never been acted on by the AU. I think there's a role for states parties to press to see that happen, to press to see that the ICC prosecutor is invited to meetings of the AU to address concerns that African Union member states may have. There's more that can be done within that context to improve relationship. And lastly, I think the ICC itself has some work to do, though it's not a communication organization, Lord knows, and it's got its hands full with its caseload and trying to collect evidence. Nonetheless, we press for better, clearer communication by the court with Africa about what it can and cannot do given its mandate. We think those steps taken up by states of goodwill and genuine commitment to the fight against impunity could help us move beyond this period of unproductive tension and criticism that has been characteristic of the last few years. Thank you very much.
Well, thank you very much, Richard, and to both of you. I'm going to open the floor in just 20 seconds, and later on, Adama may want to respond to your recommendations. I'm still reeling from yesterday's discussion on South Sudan, and your comment a little earlier with regard to the Commission of Inquiry being established by the African Union as a bold step. Yesterday, the tone was totally different. There was huge questioning as to whether the African Union had any intention to do anything that could be so construed. And basically what got said was that this would depend on whether the Commission of Inquiry actually named names and was very blunt about responsibility, i.e., namely the president of South Sudan and the former vice president, rather than some low-level individuals who are out in the field killing people, of whom there are many. So, you know, it seems to me maybe the jury is out on the question of the impact. And of course, it may be a kind of not completely fair, but there's a sense that some parts of the African Union is still a kind of an all-boys club where they protect themselves from this kind of action. So again, you know, you may want to later on sort of add something, or you want to do it now, or wait, you want to say something?
Well, I mean, I'll simply say that I totally disagree with those views. I mean, as I was saying, there is still, unfortunately, a lot of prejudice when it comes to Africa. I mean, at the time when the African Union decided to establish this Commission of Inquiry, I got many calls, many emails saying, oh, what is this? This commission is led by Obasanjo, a former head of state. This commission, among its members, have Mahmoud Mamdani, an academic who just published an op-ed co-signed with Thabo Mbeki, in which he was highlighting reconciliation. So I said, so what? So what? Let's give a chance to this commission. I think this was really a historic decision. For the first time, the African Union saying, we are no longer going to allow atrocities being committed and sitting without doing nothing. They decided to put in place this Commission of Inquiry. Despite their meager resources, they put $1 million. And I met recently, when I left Juba, with the members of the Commission of Inquiry. And hopefully, I will name, there are people, some government who are willing to help. For instance, to send next week, they will be on the ground with forensic experts, which I have been able to find. So give them a chance, God. And when it comes to the two leaders, Salva Kiir and Riek Machar, I met with both of them, and both of them are saying they are committed to not allow these cases. But you have, on one hand, is the commanders on the ground. But I said we should not discourage the African Union. Rather, we should do every effort to accompany. That's why I was talking about how we can strengthen domestic jurisdiction. And I said here also, and I'm glad that the High Commissioner for Human Rights, Navi Pillay, was with me, agreed also to provide technical assistance to that commission. Although some of our staff were not of the view, oh, I said, let's stop. Prejudice kills. We saw prejudice killing Tutsis in Rwanda, but prejudice also kills initiatives like the one which is going on from Addis and these people. So that's all I would say on this issue of the COI.
That's great. Thank you very much.
Actually, just a quick word on that. I think certainly the AU's quick decision to create a commission of inquiry puts a spotlight on what its findings will be, and we await those findings. I recall it was the Mbeki Commission on Darfur several years back, which actually came up with quite good recommendations for national prosecutions within Sudan. The problem was those recommendations were never acted on. So I think you've got both the question of recommendations and what their content is, and then the implementation. And I think we hope for the best and look to see what emerges.
Well, these are really important points. You've also, both of you, really put a kind of a global spotlight on these issues, that they're not only African, and your points about Palestine, DPRK, and Syria really sort of highlights that this is not limited. These discussions about impunity and accountability are not limited to Africa. So I'd like to open this up. I'd like to encourage you only to ask a question and not make a speech, and to be brief, so we could come back to our panelists and to identify yourselves. So, and is there a microphone? Yeah. So the lady here, the gentleman here, and if there's a third person, we'll do that. So could you stand up and identify yourself?
My name's Karen Colvard. I work for the Harry Guggenheim Foundation. Both of you have said some inspiring things, but they're the same things we've been hearing about the ICC for some time. Impunity's bad, the complementarity clause will strengthen African courts, etc. Can either of you name a clear success by the ICC, from indictment to legal collection of evidence, from direct sources to a trial, to any evidence of deterrence or strengthening of African courts? It seems that mostly we've been waiting for that success to happen, and if it doesn't happen soon, a lot of confidence in the ICC is eroding.
The gentleman here in the first row.
Thanks. Hi, my name is Kevin Kelly. I write for The Nation in Kenya. I have a question also taking off from yesterday's panel about South Sudan, which Ambassador Hirsch referred to. The gentleman, David Dieng, referred to his support for a hybrid tribunal in South Sudan. Ban Ki-moon also mentioned that yesterday, and the UNMISS Human Rights Report endorsed it as well. Isn't this a negative development for the ICC, in that you would think that the ICC would be the court of really first recourse in a situation like this, but it's being diluted because of the ICC's negative reputation in Africa now? Wondering what both your opinions are about that.
Okay. Somebody else like to come in here right now? Sorry, please, yes.
Bill Pace with the Coalition for the ICC.
Speak up, Bill.
First, I wanted to say that I very much appreciated the emphasis on strengthening regional and sub-regional international organization institutions. This is fundamental if this new system of global justice is going to succeed. Two, that it was covered that this is a very long project, as were the ad hoc tribunals. Now the ICC will be, and major powers will take different sides over time and try and kill it sometimes and support it sometimes, etc. But the lack of universality of ratification or application of jurisdiction, as Richard said, is a fundamental challenge that will always be difficult to understand. But I do want to just emphasize, and exactly in Sudan, hybrid is because whenever a situation is protected by a permanent member's veto, you're not going to get a referral. So it has nothing to do with a bad comment on the ICC. It has everything to do with the dysfunctional and inappropriate use of the veto by Security Council members. But I do want to say that I think of the ICC as four major organs: the registry, the prosecution, the judiciary, and the Assembly of State Parties. All four of those organs have a huge amount of improvements they have to demonstrate over the coming years. There will be an election of 6 judges this year of the 18 judges of the court. And history has shown us that even the biggest powers are nominate judges that are not qualified or can't serve or don't have law degrees. And then the next year they come back and say, we're going to not pay for an inefficient court. But so we have got to get the governments to make the nominations of the leadership of this court, of the judges, the highest priority this year. And that will also help, I think, with the long-term issue in Africa. But we have a situation in Kenya now where we have 2 defendants that have much greater resources than the ICC has. And they're demonstrating it in the way they are proceeding with their cases.
Let's go back to the panel. You want to answer these? You want to start?
Okay, no, I'm glad to start.
Sure, whatever. Whichever one of these questions you like. You go ahead.
Well, just to say, I mean, you know, I've worked on the International Criminal Court for nearly 20 years, but we're not, while a real supporter or an advocate, we're not a fan club. We're not a cheerleading squad. And I'm addressing your question, ma'am, in terms of success. So I think it's important to take a supportive but constructively critical posture towards the court and not just sweep under the rug real problems. As Human Rights Watch, we have made it our business to identify and publish what we think are shortcomings in policy and practice on some of the different organs of the court that Bill Pace referred to. And it's been tough going for the court. One, because creating an institution like this is not going to be easy. Coming from scratch. It's got limited authority. It can't arrest anyone who its judges have issued warrants for. It depends on the cooperation of states, some of whom have proven to be indifferent or hostile to cooperating with the court, as we've seen. So there are real objective problems. I think there have been missteps in policy that we've tried to, in a constructive way, call out. I'm glad to go into what those are. We're encouraged by the new prosecutor's new strategy for the next 3 years, which addresses some of what we saw as shortcomings in the first prosecutor's approach. But as to what is a real success, to me, the real success of the court, and this is tough to measure, is giving accountability a permanent address. In other words, the reason the Syrian protesters carried those signs saying send Assad to The Hague is because of the existence of the court and the expectations that the court has created. And I think those expectations, while not delivered on in the way they need to be, and I hope will be, creating those expectations is a very positive step. As you indicated, there have been 2 convictions, 1 acquittal. Over 11 years' time, that's not a great track record, but I think there are real plans underway to really make the investigative process more efficient and the level of investigation or quality of investigation improved so that the court will be able to rise to the level of expectation that its existence has created. And to the extent that it fails to do so, I think it's incumbent upon all of us to criticize it in a constructive way, not in a way, however, as we've seen some criticism, to undermine it.
Well, I simply would add to what Richard said regarding the measurements of success. And I think the lady who raised this question is well-founded to say so. I mean, most of the time we do hear, what did the ICC achieve since its increased force of the Rome Treaty? I think we have to realize one thing. International justice can take time. And of course, justice delayed is justice denied. I mean, by the time the ICC rendered its judgment, its first judgment, how many of the victims passed away did not witness really the rendering of that decision. But this, of course, do not undermine, I would say, the success. That was the first cases being handled. And if I go back to the ICTR, just by way of analogy, you will realize it took also so long before they upheld the first decision. But it was a historic decision. The first time the Genocide Convention was applied before a court. The first time rape committed under certain circumstances was equated to a crime against humanity. So that was important. And I still remember one Rwandan journalist whose entire family was killed. There were 11 members of his family. The day the judgment was passed, a sentence of the reminder of his life, of the person who killed his family, he called me, said, "Mr. Registrar, this is the most beautiful day of my life. Today, to me, if the ICTR was costing billions of dollars, I don't care. To me, this has no price." So can you believe that decision for him had no price? And that's why when people were saying international justice is costly, yes, it is costly. But at the end of the day, we are talking about the victims. And that's where also I do believe it is extremely important that we pay attention to the victims. And this brings me to the question you raised about the hybrid tribunals. One may, of course, argue, now that we have the ICC, is it necessary to establish ad hoc tribunal, to establish hybrid tribunals? I would say ad hoc tribunal no longer. And I think the lessons learned from ICTR, ICTY in terms of length, 20 years down the road, these two tribunals are still there. I think that forget about it. Now, if we talk about hybrid tribunals, I think the Special Court for Sierra Leone has shown, when it comes really to outreach, that having the tribunal close to the victims is something extremely important. And that was one of the reasons earlier I was arguing that at least if you cannot have the trials taking place in DRC, have the trial taking place in Arusha, you know. And in South Sudan, I would not exclude an hybrid tribunal, providing, as it is said by the Assembly of the State Party in their own resolution, we have to make sure that those trials are fair, that all parties, their rights will be respected. That, to me, makes sure that we will be following the international standards of a fair trial. I mean, as long as that is done, I would say yes for an hybrid tribunal. Make sure that you have the expertise. And this brings me to the concern raised by Bill Pace. In that regard, I think it is extremely important to maybe revisit the selection process, the nomination process. Because at the end of the day, if you have a judge who never entered a courtroom in his life, and all of a sudden being nominated for election as a judge, it will take time for that judge really to understand. And we have had a case where you had a judge who never entered, I would say, a courtroom. You know, so we need to take more seriously this issue of nomination. And that's where I would even encourage maybe to have a kind of a vetting process to make sure that ultimately those who will be nominated for election as judge are the best among the judges possible, who have experience on criminal litigation, etc. You don't bring someone like my daughter, who is a business lawyer, to become a criminal judge. So I think it is extremely important that but this is, of course, the responsibility of the state parties. And that is where I think that the state parties should really pay more attention. Because at the end of the day, that will have even impact on the funding. Because if you have people who are not really that qualified, it will impact, because the cases will be delayed. But another important aspect also I think we need to pay attention is the rules of procedure and evidence. We have seen that if you take the common law, the civil law, you will see sometimes that it's much faster. Of course, each of these systems have its pros and cons. And I think we need to come one day with a system which can be a kind of, let's say, not a hybrid system, but really the best system possible, taking into account all the elements which will at the end guarantee a fair trial, but which will make cases being dealt speedily and efficiently.
Well, your comments just now to both these questions kind of underscores the two interrelated matters of the capacity or ability, if you want, of the judiciary in different African countries, and whether, you know, in South Sudan that judiciary exists and is up to it in terms of strict qualifications. And then again, it came up yesterday, you know, how long would it take to set up a hybrid tribunal? How many years once it was set up would it take to have judgments? So, you know, there's, you know, and how long until people have died who were the witnesses, or they've disappeared, or they can't remember, and so on and so forth. So it's very challenging to sort of move toward some of the recommendations that are being offered. This does not vitiate the recommendations. It just kind of underscores the complexity of achieving them. So we're going to have one last round. We're going to wrap up absolutely no later than 2:45. So Ann Phillips, and then the lady in the second row. And if there's one more, the gentleman in the back, and then we're going to go back to the panel for their wrap-up remarks. Ann, you want to stand up, Ann, please? And just,
not particularly, but I
well,
will.
Even if you don't want to.
No, it's fine.
And look at everybody as well as us, so they can all hear it.
Look at everybody?
Oh, I like this. You know, the way you are, halfway.
Well, my name is Ann Phillips. I'm a member of the board of IPI, International Peace Institute. Before I ask my question, I want to thank both of you for being with us today, and really thanking you so much for devoting your lives to this immensely important issue or problem that the world is facing. So thank you for that. My question may be somewhat naive, because although I have a rather general knowledge of the workings of the International Criminal Court, I don't know many of the specifics. Now, Mr. Dicker, you have referred on several occasions during your presentation to the charter and flaws in the charter. And it seems to me that the charter is deeply flawed. And many of the processes and the criticisms you have could be rectified if the charter were changed. Now, perhaps I'm wrong. I don't know. As I said, I'm not that familiar with the details. Has there been discussion about changing the charter in the same way that the Security Council, there's a lot of discussion about changing and reforming that? And what would the process be? Is it within the realm of possibility to do that?
And anything you can add about the Assembly of the States Parties that met in December, and whether any, you know. So the next was with the lady in the second row. Please.
Thank you. My name is Tamara Cummings-John. I'm from the Office of Legal Affairs. So the prosecutor announced today that she's reopening preliminary examinations into the events of Iraq, into the conflict, and in particular into alleged crimes that were committed or may have been committed by UK forces. So in this regard, I wanted to find out from panel members what they thought, if we were to proceed to investigations, how forthcoming do you think Western governments will be in terms of cooperation? Thank you.
This has to do with the United Kingdom's alleged torture of detainees in Iraq. Is that correct? That's correct. Yeah, very good. Thank you. The gentleman in the next to the last row.
Thank you. Good afternoon. My name is Leandro Mission of Brazil. I can't resist, but benefiting from the wisdom of the panelists, to ask how constructive could civil society be in addressing two issues of a structural nature that, in my mind, go to the core of the issues that the ICC deals with. One is funding. There has been mentioned here that international justice is costly. Well, it is indeed, but some clearly are not willing to pay for it. Currently, it seems that from the very first referral till the draft that the security members have in front of them, the issue of funding remains a big one. So you basically outsource, or you intend to outsource judicial accountability, but to an independent institution, but you're not willing to pay for it. This is a fundamentally unfair situation in my view. A second issue goes to the core of the idea of rule of law and equality of all before the law. It seems that to this very day there are people who deserve more attention by the law or by the judicial protection than the others. I'm referring specifically to the carve-outs of the proposed language that comes from many years that certain individuals are exempted from ICC jurisdiction based purely on power politics. Thank you very much.
Very good. So, as you wish, but sort of these will be your wrap-up remarks, and then we'll close the session. You want to go again, or?
Well, I mean, just on the last point you made, and by reference, I would simply illustrate with the universal jurisdiction as it was being applied in Belgium at the time. And as you may know, Belgium was really a pioneer in that area until the time when, because of many NGOs calling for an American general to be brought, calling for Sharon to be brought, then Belgium had to amend its legislation. And that was very important. That means when politics enter the judicial arena, it makes a lot of damage for the victims. So how to make that impossible? I mean, it's a fight I hope the civil society will continue to do. I mean, as you know, we mentioned it earlier regarding Article 98, the efforts made at the time by the Bush administration. I mean, all that, of course, did not help. And Dick was right to say about the narrative. But still, two wrongs don't make a right. And I think for the time being, what we are looking for is to make sure that the victims really found their ways and at the end of the day be satisfied that justice has been rendered to them. And in that regard, it is even very unfortunate that when it comes to reparation, the ICC funds for victims, I would not say that it is depleted, but it's almost non-existent. And all these expectations may have, of course, tomorrow an impact, a negative impact on the ICC. And that's why I think it is critical that the Assembly of State Parties pay more attention in trying to see how also to strengthen the civil society on the ground. I mean, in their resolution here, they are calling on the civil society, for instance, if I take the resolution on complementarity, to help at the domestic level. But they need resources. They need resources. I mean, the excellent work, which is almost, I would say, unique, being done by the NGO Coalition for the ICC and for the R2P. I mean, one need to do it, but you need resources for that. And this is really something I hope will be taken more seriously by the state parties. And to conclude, my last word will be simply, once again, John, thank you for inviting us to interact with this audience at a time when there are so many challenges ahead of us, particularly in Africa, the crisis in South Sudan. But as he did say, today everybody is standing to see what can be done. What can be done to avoid atrocities being committed, further atrocities. What can be done also to address the issue of accountability. Because at the end of the day, that is what is critical. Make sure that impunity will no longer be allowed in Africa, but elsewhere also. But in Africa, at least, the decision is taken. Before there was plan of action, maybe there was not action, but I can tell you now action will follow the words. And it is very unfortunate, as you said, in the case of the Thabo Mbeki report at the time, although I do not see it really as a human rights commission of inquiry of the atrocities being committed. They came with certainly a number of recommendations, including the national prosecution. I remember at the time I was not among those in favor of a national prosecution simply because I was at the time of the view that the size and the quality of the judiciary in Sudan was not really, the judiciary was not of a size and a quality to try those type of cases, crimes against humanity, etc. And there was not a proper legislation as well. But we have seen cases in Ethiopia where for the first time at a national level, before Guatemala, genocide was tried, even if it was in absentia, the case of Mengistu and his 50 allies. So let's hope simply that things will improve. I mean, I mentioned it, the case of Guatemala, because I sent one of my staff to observe the trial. Of course, later on, the Constitutional Court decided to rescind, but at least it shows that where you have the victims getting together, where you have the civil society behind them, where you have a state which is committed to address the issue of accountability, something is possible. But we have to continue to fight. We have to continue to fight. Never, never a state will give you something like that. I mean, we know United States. I sent the first team to investigate death penalty in the United States. I sent the Chief Justice of Zimbabwe, the senior legal counsel from India, who later became the president of the Legislative Committee of India, to come and look into the rule of law and death penalty in the United States. It was simply shocking in a courtroom in Georgia to find a defense counsel who arrived there drunk because he was simply being appointed to defend someone who finally was sentenced to death. So to say that even the United States has a long way, there is nowhere in the world where you have a perfect system. And therefore, we have to accompany these processes going on. And with this, once again, thank you very much, John.
Okay. Thank you. A couple of thoughts to the questions put forward. Yes, indeed. The Rome Statute does contain flaws. I think the key in understanding all of the tension that may exist, or tension with the implementation of the treaty, is that it was created by states, very jealous about their national sovereignty, right? So what's in the Rome Treaty reflects a negotiated compromise among 150 states about what they were willing to give up. And there are real shortcomings that one sees in the treaty one would like to correct. I'm weary about opening the Rome Treaty up for widespread amendments. I fear it would be like opening a Pandora's box, but I think there are changes that can be made through amending the rules of procedure and evidence with the objective of expediting the procedure before the court so that its track record could improve. In regard to the United Kingdom, I'm so glad you mentioned that, because just today, this morning, the prosecutor announced that she was reopening, as your question suggested, a preliminary examination of allegations that British military tortured Iraqi detainees in the course of their occupation and presence there. This, to my eye, is a very refreshing development and a step, and I don't know where it's going, but a step that suggests movement in the direction of evening out a bit the playing field. And how will states, the United Kingdom, France, etc., see cooperating? Well, they need to be held to the same standard as the government of Kenya, the government of Cote d'Ivoire, in terms of obligations they have undertaken to cooperate. And if they don't, they need to be called out on it. The British issued a statement today in response saying this is totally without grounding in fact. Well, if that's the case, they've got nothing to hide. So their information should be forthcoming, which takes me to Leandro's point, two very, very good points about funding and a carve-out. Again, this funding issue is really scandalous, and what the question is getting at is when the Security Council, in its wisdom, refers a situation to the court by result of U.S. government insistence, the referring resolution precludes United Nations funding for that investigation and prosecution. So it really is a freebie on the part of the non-state parties on the council, because who pays for it are the state parties who contribute assessed contributions to the court's budget. I've heard some people suggest that that provision violates aspects of the United Nations Charter, which gives to the General Assembly, not the Security Council, decision-making power over funding. I would love to see UN member states push that forward and suggest to the Fifth Committee adopting a resolution to fund the court's investigations in Darfur or in Libya. I think it's outrageous, and you won't be surprised to hear me say the same kind of thing in regard to the carve-out, which exempts specifically nationals of states that are not party to the Rome Statute from the court's jurisdiction arising out of events in that country. So what you have is a situation where those non-state parties on the council subject another non-state party, be it Libya or Sudan, to the authority of a judicial institution that they have protected themselves from every which way they can. And that, to me, is the embodiment of hypocrisy on the side of justice and double standard, and it needs to change it. I'm encouraged in thinking back to the Security Council resolutions the Bush administration pushed through in 2003 and 2004 on the Security Council that essentially said the same thing. And that resolution, which had to be renewed every year, was renewed when the events at Abu Ghraib prison in Baghdad came to light, and many on the Security Council told the United States government, seeking to renew that exemption for the benefit of its own nationals, this is a hell of a time to be talking about exemption for your citizens from allegations of serious crimes. And that resolution in 2005 was not renewed. I think we've got to have that long-term vision to these very objectionable provisions, Leandro, that you've cited, and work to pull them out from future referral resolutions. Will take time, but that's got to be the objective. And John, thank you very much.
Well, you know, we're all incredibly in your debt, Adama and Richard. You know, an hour and a half here, you've just spoken about a long-term vision. In this little hour and a half, we've gone back at least 20 years to 1994, and we've opened this thing up to the globe. Because we're not just talking about Africa, but we're talking about Asia, Europe, the United States, all these shortcomings that our own country, those of you who are Americans, face. All you have to do is look at the front page of the New York Times this morning and the upcoming execution in Texas to know what I'm referring to. But both of you have given us that incredible perspective, and you brought your experience and your insights. And what I really value is that you both are hopeful after 20 years or more working on these issues, because it's easy to get discouraged. I mean, I went away from this meeting yesterday at 2 o'clock after listening to these two wonderful South Sudanese, you know, virtually, you know, in terrible circumstances. But as you reminded us, people in Rwanda were in terrible circumstances, not to make anything better in South Sudan. I mean, that's not the reality. But things can be done about these issues. So you've both given us this sense that there's much more can be done. So everybody here, thank you very much.